Okay, today we're gonna talk about due process. Let's look at page 241 of the source book, Goldberg versus Kelly. It is a case where someone was denied, someone was dropped off from welfare benefits without being given a hearing on whether he should be dropped off. And the court here says such deprivation, such a denial of benefits is unconstitutional on the ground that it didn't satisfy the procedural requirements of the Constitution. So the court actually does not go into whether this particular denial was okay or not. You know, it's possible that he was denied welfare benefits because he had some income that he didn't report before, or he had an asset that he hid from the government. But the court does not go into that. Regardless of whether he was qualified to receive the benefits or not, the court says it was unconstitutional. It was unconstitutional to stop giving the person the benefits, stop giving the person the welfare benefits without going through, without meeting the procedural requirements. So, what is that procedural requirement? And where does the procedural requirement come from? The 14th Amendment of the Constitution, 14th Amendment of the Constitution, we talked about 14th Amendment of the Constitution only in the context of, to talk about equality, equal protection. But also there is another provision, another paragraph in the 14th Amendment, which says, no one shall be deprived of life, liberty, or property without due process of law. No one shall be deprived of life, liberty, or property without due process of law. 한국에서는 소위 적법 절차 조항이라고 부르는 겁니다. So, what does the Supreme Court say is the due process of law in a case like this? What process should the state have taken in stopping the provision of the welfare benefits? Well, the answers are all there, right? Pre-termination evidentiary hearing. So there has to be a hearing. 청문회라고 하죠, hearing. Hearing who? What do you need to hear? Well, hear both sides. The government wanting to terminate the benefit and the person whose benefit is being terminated. And it has to happen pre-termination. So, if you look at source book page 243, the lower court, already made a decision that pre-termination hearing is required under due process. The district court held that only a pre-termination evidentiary hearing would satisfy the constitutional command and rejected the argument of the state and officials that the combination of the post-termination fair hearing with the informal pre-termination review disposed of all due process claims. So the state, the government doing the termination made an argument that, hey, we'll terminate first, and then we can terminate first, and then the recipient, if he or she feels his rights were violated, he can then request a hearing. We don't have money and resources to give hearing to all the recipients before taking actions. We found somebody was receiving welfare benefits by mistake. We have no obligation to pay the benefits when they're not due. Why should we spend government money for any additional period of time when we know that he should not be receiving the benefits? So we'll terminate first. And if he resists, then we can have a hearing. That was the government's argument. What does the Supreme Court say about that? The lower court first said, all the way at the bottom of page 243, while post-termination review is relevant, there is one overpowering fact which controls here. By hypothesis, a welfare recipient is destitute, poor라는 뜻이죠. Without funds or assets, suffice to say that to cut off a welfare recipient in the face of brutal need without a prior hearing of some sort is unconscionable unless overwhelming considerations justify it. Two lines below, against the justified desire to protect public funds must be weighed the individual's overpowering need in this unique situation not to be wrongfully deprived of assistance. So that was the district court's decision, and about 2, 4, 6, 8, 10, 12, 13th line, the court says, we affirm. The court says, one line below, such benefits are a matter of statutory entitlement for persons qualified to receive them. Their termination involves state action that adjudicates important rights. The constitutional challenge cannot be answered by an argument that public assistance benefits are a privilege and not a right. 권리가 아니고 특권이기 때문에 적법 절차 없이 보호를 중단할 수 있다. 이런 주장은 거부돼야 된다. 설명이 그 뒤에 나오죠. Relevant constitutional restraints apply as much to the withdrawal of public assistance benefits as to disqualification of unemployment compensation, or to denial of a tax exemption, or to discharge from public employment. If welfare benefits are if welfare benefits are a privilege that can be cut off without constitutional constraints, then you can say the same thing about employment, right? You can be fired without a hearing. The court says the court saying, we cannot accept such result. Now, are there benefits that can be terminated unilaterally without giving a hearing? Look for the sentence where, look for the footnote 29. I mean, not the footnote itself, but just a part where footnote 29 is located. And it says, it is true, of course, that some governmental benefits may be administratively terminated without affording the recipient a pre-termination evidentiary hearing. Now, what could be those benefits? The court does not make it clear what those benefits are, but the court is saying, but we agree with the district court that when welfare is discontinued, only a pre-termination evidentiary hearing provides the recipient with a procedural due process. Okay, so that's the contour of the basic law of the case Goldberg versus Kelly. Basically, that when state wants to discontinue, if the state wants to stop providing for vital needs, here the Supreme Court adopted the language used by the district court, brutal need, right? I mean, having to eat, not being able to, not starving, I mean, this is a brutal need. Having a shelter to live in. So that's the basic law. But is it true that the state has to always give the person some hearing before restricting his or her right? Think about it. Are there times that state will take away something from you without giving you a hearing. Anyone? Yes.
Emergency situations.
Okay, emergency situations. Like when?
Like war, for example.
Okay.
Public disturbances.
What do they take away from you?
And they can limit certain your freedoms.
They can restrict your freedom. So they can arrest you.
Yes.
Right.
And property as well, I guess.
Right. Sometimes in time of war, they'll take away your property. For instance, cars, and especially big ships like Sewol Ferry is one of the vehicles that will be commandeered by the state in time of war. So that is the force. So only in those situations, only in those emergency situations, the state can act unilaterally. Well, any other time, like non-emergency situation, the state can act unilaterally.
Are you only talking about the situation where the state gives you privilege and takes it away?
Well, if it's just taken away, it's worse, right? Probably the state needs to provide more procedural safeguards in taking it away than when it's taking away what's yours, than stopping providing what was not yours, right? So, yeah, broaden the discussion to include situation where the state just takes away what's yours. Tax. Okay. But how do you pay tax? How do you pay tax? Does government come and just take it away? No, right? The government will send you a notice that you have to pay this much tax, right? And then we'll create some sort of hearing. We'll give you some sort of a chance to resist and explain your position. And if possible, the state may sue you. State may try to prove its case in a court of law. There are times that your tax is paid out of your paycheck, but it's not the government actually taking it away. You are voluntarily, you are required by law to withhold some amount of, the employer is required to withhold some amount of your paycheck to pay off your future tax liability, and then the employer will make the payment. It's not a situation where the government just takes away money from your bank account or your employer's bank account. One situation that you can think of where the government acts unilaterally is search and seizure, criminal investigation. But there, That's the question. Does the government act unilaterally in that situation? We'll talk about that. Okay, we'll talk about that in the next case. But for now, if you just look around, you realize that there are not many things where the government interfere with your life without first giving you a hearing on why you should not be deprived of what the government is taking away. So here, what is the government's argument when the government says they can stop providing welfare benefits? They can stop providing welfare benefits without giving the hearing. What's the government's argument? Sourcebook page 245. The second paragraph. Appellant does not challenge the force of these considerations, but argues that they are outweighed by countervailing governmental interest in conserving fiscal and administrative resources. These interests justify the delay of any evidentiary hearing until the discontinuance of the grant. Summary education. Summary 그러니까 히어링 없이 하는 걸 얘기하는 거죠. 일종의 직결 처분. Summary I'm sorry. Summary hearing. Sorry, I skipped the line. So summary hearing. Summary adjudication protects the public fisc in the public fiscal resources. Public fisc by stopping payments promptly upon discovery of reason to believe the recipient is no longer eligible. Since most terminations are accepted without challenge, summary adjudication also conserves both the fiscal and administrative time and energy by reducing the number of evidentiary hearings actually held. So, hey, the government can, make accurate decisions most of the times. Yes, we can give the recipients hearings before termination, but most cases, the government is right. 90% of cases, the government has no reason to terminate benefits without having some substantial basis. The government, for that reason, when the government decides someone is not eligible for benefits, the government is usually right. The government will be wasting a lot of money and time, both in preparing for the hearing and also in continuing welfare payments. Why should we waste that much money and thereby reducing the benefits that other people can receive. Right? I mean, all this money come out of the same pocket. Tax dollars. Tax money that people pay, right? So the government is almost always right in terminating the benefits. Then instead of wasting so much time and resources on the 90% of the cases, in continuing the benefits, in continuing wrongful benefits, right? And preparing for hearings, we could increase the welfare benefits that we pay to eligible recipients. What does the court say about that? All the way at the bottom, well, I mean, we can go into the middle a little bit. The third paragraph, page 245, third paragraph, much of the drain on the fiscal and administrative resources can be reduced by developing procedures for prompt and pre-termination hearings and by skillful use of personnel and facilities. Indeed, the very provision for post-termination evidentiary hearing in New York's home relief program is itself cogent evidence that the state recognizes the primacy of the public interest in correct eligibility determinations, and therefore in the provision of procedural safeguards. So that is that is how the Supreme Court answers the government's argument that we'll be wasting too much time and resources when we will be proved correct 90% of the time. What is, so, what are the requirements themselves? I mean, you can read page 245 and 246, but instead of doing that, we can get a summary. I mean, since we know the reasoning, maybe we can save time just by reading the summary, which is page 242. We can look at the third holding. 3.A, such a hearing need not take the form of a judicial or quasi-judicial trial, but the recipient must be provided with timely and adequate notice detailing the reasons for termination and an effective opportunity to defend by confronting adverse witnesses and by presenting his own arguments and evidence orally before the decision maker. Okay. So what are the requirements? There has to be timely and adequate notice. Number one. Notice of what? Well, notice of termination. And then there has to be opportunity to defend. Okay? And B and C are pretty self-explanatory and pretty commonsensical. So again, notice, and so there has to be notice of termination, and there has to be hearing, where the affected person can present his or her defense. The third one is in the D. What does D say? The decision maker must be impartial, and although prior involvement in some aspects of a case will not necessarily bar a welfare official from acting as a decision maker, he should not have participated in making the determination under review. So impartial judge has to be provided. But so I mean impartial decision maker. But what does this mean? Impartial decision maker. I mean, who is considered impartial and not on the for the government to meet this demand of due process, it has to hire people. It has to hire the decision maker, right? So decision maker will be paid by the state. Well, then already the decision maker runs the great risk of not being impartial, right? Because the decision maker will be employee of the government. Can you think of the employees of the government who are considered impartial, who are considered not on the side of the government? Any profession? Judges, right? But the court said, hey, it doesn't need to be judicial hearing. Okay, you don't need judges. And judges are expensive. I mean, judges are busy putting dangerous people into prisons. We cannot waste the valuable judicial resources for a hearing which is only of temporary nature. What do you do? Well, after this decision, Goldberg versus Kelly, the US government hires a lot of lawyers as administrative law judges, ALJs. And ALJs, administrative law judges, are a particular product of the US Constitution. They are not judges, they are part of the executive branch. And yet, they have to maintain impartiality and independence from the executive branch. all for the purpose of providing due process. I'm not fully familiar. Okay, so that's the deal, but let's be clear about one thing. Let's say you are receiving welfare benefits, and suddenly the welfare benefits stopped coming. Okay, without notice. Are you really without any remedy? Is there something you can do? I mean, put yourself in the mind of the welfare recipient. Right in Korea. Let's say welfare payment stopped coming. What would you do? Lawsuit, yes. So you are not without remedy, right? I mean, when the government says, hey, we are wasting resources, it is a very serious argument. See, if there is anyone wrongfully terminated, he can always go to court and file what? In Korea, 행정소송, right? In administrative lawsuit. And get a remedy there. And if possible, you can even get a temporary restraining order, 가처분. So you can have the administrative 행정소송에서 가처분을 받을 수 있나? 행정소송법 공부한 사람 없죠. Okay, so strike that. But what's important is you can challenge in court promptly and recover your ground. (2013년도에) 행정소송제도에서도 가처분을 도입한다라고 했는데 실제로 도입됐는지는 모르겠네. 가처분은 아니라 집행정지 처분을 할 수 있지. 집행정지 처분을 하면 가처분하고 똑같은 효력이 나죠. 그렇지. Because it's the government taking action, and by obtaining an order to suspend the government action, you can create the same effect. You can obtain the same effect as you are applying for a temporary preliminary order. 가처분 preliminary order예요. Provisional order. So you can get the same thing. So all of that is available as soon as your benefits are stopped. Why waste so much money, right? So this is a point where welfare benefit is stopped. Once it's stopped, so time flows this way. You can go to court. So you can seek judicial review. And even in the judicial review, you can have, provisional order stopping termination. So provision owner stopping of the benefits, right? So that way you can keep the benefits. All this is available. Why do you need to set up another predetermination hearing, wasting lots of money? You know, all that money can fit maybe another qualified person. But still, because of Gold versus Kelly, the US government is spending a lot of money, especially hiring administrative law judges. There are many of them, to provide the due process to the people of the United States. And let's compare that to the Korean situation. What does due process clause mean in the Korean Constitution? Do we have a similar provision in the Korean Constitution that says no one shall be deprived of life, liberty, property without due process of law? 한국헌법에서 적법 절차라고 하면 보통 어떤 내용이에요? 조항이 어떻게 되죠? 체포, 구속, 압수수색은 그렇죠. 네. So, the Korean Constitution, I'll say, have the same provision as to life and liberty, right? If liberty includes like privacy, but there's nothing on the property. And welfare benefit is, I guess, welfare benefits and many other things of a valuable nature can be considered property. And stopping providing these welfare benefits in Korea can take place without predetermination hearing, it seems. 근데 이제 실제로는 헌법상 요구되는 건 아닌데, 어찌됐든 먼저 뭔가 권리든 특혜든 먼저 박탈을 하고 억울하면 소송을 제기하라는 것은 이제 야만적이다라는 어떤 상식적인 또는 도의적인 상식 또는 상식적인 도의, 뭐 어느 게 맞는 말인지 모르겠는데 그런 거에 따라서 한국의 행정절차법이라는 게 만들어져 있죠. 그래서 행정절차법을 보면 그 국민의 그 권리를 박탈할 때는 이러이러한 절차를 충족해야 한다라고 하면서 비슷한 절차들이 있어요. 그러니까 비슷한 요건들이 있어요. 그런데 그 요건들이 그 요건 세 가지가 뭐라 그랬죠? 그러니까 이 골드볼 vs 켈리에서 세 가지 요건은 notice, advance notice, 사전적인. 그다음 두 번째, 그렇지, hearing. 그러니까 hearing이란 건 뭐냐면 opportunity to defend. 세 번째는 neutral decision maker. neutral decision maker at hearing. 한국에서도 이런 적법 절차 요건에 대해서 적법 요건을 충실하게 이행을 하려면 이 ALJ들을 많이 고용을 해야 돼요. 판사는 아니지만 정부의 입장을 대변하는 게 아니라 정부와 개인 사이에서 중립적인 결정을 내릴 수 있지만 그 일을 하는데 누가 돈은 줘야 되잖아. 국가가 줄 수밖에 없죠. 그런 사람들이 사실은 많이 필요한데 실제로 그렇게 되고 있진 않죠. 그래서 그냥 일선 공무원이 그러니까 자기가 하는 일인데 물론 이제 행정심판위원회들이 있죠. 근데 행정심판위원회들은 반드시 프리터미네이션이 아니고 포스트 터미네이션 이런 것들이 많다고. 프리터미네이션 뭔가 국민에게 불리한 행위를 하기 전에 그 전에 의견을 듣고 중립적인 판단을 하고 이렇게 하려면 그런 그런 것들이 한국에서는 그냥 일선 공무원이 자기가 하는 일에 대해서 결정을 내린다거나 이런 일들이 발생을 하죠. 그러니까 자기가 하는 일에 대해서 자기가 중립적인 판단을 내린다거나 이렇게 되면 안 되는 거죠. 그러면 중립적인 게 아닌 거지. Let's look at dissenting opinion of Justice Black. What does Justice Black say? Well, he also talks about how financially burdensome it will be to prepare a hearing and also continue giving the benefits during the hearing. Okay? And how all that money and resources spent on preparing hearing and continuing the benefits can be saved for the benefit of other recipients who have no problem with their eligibility. So he says, page 249 at the bottom, the problem So let's read the last paragraph. The problem in this case is similar to that frequently encountered when two parties have an ongoing illegal relationship that requires one party to make periodic payments to the other. Often the situation arises where the party owing the money stops paying it and justifies his conduct by arguing the recipient is not legally entitled to payment. The recipient can, of course, disagree and go to court to compel payment. But I know of no situation in our legal system in which the person alleged to owe money to another is required by law to continue making payments to a judgment-proof claimant without the benefit of any security or bond to ensure that these payments can be recovered if he wins his legal argument. Yet today's decision in no way obligates the welfare recipient to pay back any benefits wrongfully received during the pre-termination evidentiary hearing or post any bond, and in all fairness, it could not do so. These recipients are by definition too poor to post a bond or repay the benefits. 여기서 계속 bond 얘기가 나오는 건 공탁금을 얘기하는 겁니다. That, as the majority assumes, must be spent as received to ensure survival. 그러니까 일반 민사에서도 예를 들어서 뭐 돈을 이자를 내야 되는 사람이 있는데 채무자가 있어요. 이자를 계속 내야 돼. 근데 하다 보니까 채권자가 채무자한테 빚진 거꾸로 상계 채권이 있다는 걸 알게 됐어. 그래서 이거 이자 내는 대신 뭐 이자하고 원금하고 합치자. 원리금이라고 합시다. 이거 원리금 내는 대신 그 다른 채권하고 상계하겠다. 그렇게 생각하면 누구라도 당장 그렇게 할 수 있는 거지. 왜 계속 돈을 더 내고 나중에 그러면 나중에 상계할 수 있는 채권 상계를 성공적으로 못하면 그럼 필요 없이 돈을 낸 거잖아요. 채권자한테. 채무자가 내지 않을 돈을 낸 거잖아요. 그럴 필요가 뭐가 있냐. 그리고 그런 경우에는 채무자가 돈을 돌려받으면 되죠. 잘못 냈던 돈은. 근데 여기는 뭐 그런 요건이 있는 것도 아니다. 이게 무슨 세금 낭비냐. 이렇게 보는 거죠. 국가가 부당한 게 있으면은 곧바로 바로 잡고 문제 제기하는 소수가 있으면 그때는 중립적인 사법적인 절차에서 처리하면 되는 거지. 왜 국가가 보기에 부당한 일이 있는데 그걸 바로잡기 먼저 행동을 취하기 전에 먼저 청문회 같은 걸 해가지고 청문회 같은 거를 준비하느라 시간과 자원을 낭비를 한 후에야 그 부당한 사안을 바로 잡을 수가 있냐. 이제 이런 얘기인 거죠. So, why? Well, because you are the state, right? This is constitutional law. The state, being so powerful, has more duties to the people who are, supposedly superior to the state itself. The state is supposed to serve the people. People are the owners of the state. The state is their servant. So if the state wants to serve its people correctly, then before taking things away, the state should provide all the people with a due process. Advance notice, hearing, and neutral decision maker at the hearing. Any question or comment on Goldberg versus Kelly? Now, if not, now we can go to page 254, Katz versus United States. Now, I mean, a lot of people don't see the connection between Goldberg versus Kelly and criminal procedure, but I see a clear connection. That's why we are reading it together. Just as property cannot be, if a property cannot be deprived without due process of law, it's obvious, right? It's obvious that liberty cannot be deprived without due process of law. And then when we are talking about due process, we are talking about advance notice. So, part of liberty is privacy. Part of liberty is freedom of speech. Or, even freedom in general. Now, if a property cannot be deprived without due process of law, it's obvious liberty cannot be deprived without due process of law. And what is that due process of law when it comes to privacy, right? Privacy and bodily freedom. That is under the 14th Amendment. So this is a 14th Amendment. There is also a 4th Amendment. And 4th Amendment says no unreasonable search and seizure without warrant based on probable cause. And I told you that I told you that clear and present danger present danger test is a form of strict scrutiny applied to freedom of speech. So, you know, strict scrutiny is strict scrutiny, intermediate scrutiny, rational basis review. This is a general standard of review. General standards of review not just apply to equality, but also liberty in general. And I told you that when the affected liberty is freedom of speech, then you apply strict scrutiny, and we call that clear and present danger, right? Now, that's a substantive. This is a kind of a substantive analysis on restriction of liberty and equality. Now, this is a procedural part, right? This is a procedural half of the universe, the constitutional universe. And here, the central concept is, nothing can be deprived life, liberty, or property without due process of law. And when that interest being protected is privacy and bodily freedom, 14th Amendment kicks in. And it says, no unreasonable search and seizure without warrant based on probable cause. So we'll take a break, 10 minutes. So we'll start again at 55. 근데 그때 충족돼야 되는 원칙이 뭐예요?
본질의 침해.
그렇지, 과잉금지 원칙이잖아. 네. 기본권 제한의 일반적인 그 헌법적 제한. 기본권 제한은 30조 이하에 그렇게 돼 있다고 해가지고 법률을 아무렇게나 만들어 제한할 수는 없는 거잖아요. 그래서 그게 충족시켜야 되는 게 뭐예요? 과잉금지 원칙이잖아. 그 비례성 원칙이라고 부르고, 그 비례성의 원칙은 뭐 목적의 정당성 어쩌고저쩌고 다 있는데 결국은 그것도 전부 다 뭐로 지적이 되냐면은 공권력으로 창출하는 공익과 그것에 의해서 침해당하는 개인의 기본권 사이에 형량 문제거든요. 그렇다고 비슷하게 미국 헌법도 기본권은 항상 공익에 의해서 제약될 수, 개인의 기본권은 항상 공익에 의해서 제약될 수 있는데 그 사이에 항상 비례성이 있어야 된다는 거죠. 비슷한 원칙이 있는 거예요. 있는데 그 평등권에 있어서는 그 불평등의 사유가 인종이나 이제 이런 경우 strict scrutiny, 또 성인 경우 intermediate scrutiny, 그렇지 않은 경우 다 rational basis review로 한다라고 이제 우리가 배웠고, 그리고 그 이유는 이제 그 차별의 사유가 매우 부당한 것으로 이제 의심이 되는 그런 역사적인 맥락이 있는 경우, 그래서 선천적인, 그러니까 사후적으로 그 불변한, 변할 수 없는 이유로 오랜 역사 동안 차별을 당했던 그룹에게 불리한 그런 찾은 대우는 스트릭트 스크루티니, 인터미디어트 스크루티니 한다라고 된 거고, 그리고 그것과 함께 리버리에 있어서도 우리나라 과잉금지 원칙처럼 자 참고로 우리나라는 원래 한 2000몇 년도에 제대국민 가산점 결정 나오기 전에는 평등 원칙은 기본적으로 평등 원칙의 심사 기준 기본적으로 자의금지 원칙이었어요. 자의적이지만 않으면 된다라는 거였는데 제대국민 가산점 결정 나오면서 뭐라고 했냐면 성평등, 특히 채용에 관해서 채용의 성평등에 있어서는 더 높게 심사를 해야 된다고 하면서 미래성의 원칙 상위 심사를 해야 된다라고 얘기를 하죠. 제대국민 가산점 입장에서. 그래서 미국처럼 차별의 사유가 뭐냐에 따라서 심사 기준을 높여요. 네, 그래서 이제 비슷해진 거죠. 이제 일반적인 자유, 그러니까 평등이 아니라 일반적인 자유에 있어서도 비슷한 이제 상황이 발생을 하는데 freedom of speech 또는 privacy 이런 것들을 이제 fundamental rights라고 불러요. fundamental right. fundamental rights에 해당되는 그 침해가 발생할 때는 strict scrutiny. 그렇지 않은 경우는 나라tional based review. 그래서 freedom of speech 근데 이제 그거를 그래서 그 freedom of speech 안에서도 예를 들어서 내용 규제, 내용 content regulation 인 경우에는 strict scrutiny지만 time, place, manner 그러니까 방법적인 제한에 대해서는 intermediate scrutiny를 하게 돼요. 또 정치적 표현과 상업적 표현을 구분해 이거 여러분들 다 배우거나 외울 필요 없어요. 이건 여기 판례를 봐야 되는 게 때문에 판례를 안 보고선 지금 여러분들이 다 배울 필요 없는데 이 구조를 이제 알고 있으면 편하니까 다 말씀드리면은 그래서 내용이냐 방법이냐에 따라서 슈익 스크린에서 인터넷 스크린 내려가기도 하고 또 정치적 표현이냐 광고냐에 따라서 광고의 경우에는 역시 심사 기준을 낮추고 왜냐면 광고는 상대적으로 표현자의 보호법이 적다고 생각을 합니다. 그래서 이런 구조, 그 개인의 사익이, 그러니까 침해당한 사익이 크면 클수록 심사 기준을 높여가지고 심사 기준을 높인다는 게 뭐예요? 더 중대한 공익의 창출을 요구하는 거죠. Compelling government interest, important government interest 이런 식으로. 그리고 그게 그냥 목표 공익만 그 응대해가지고는 안 되고 그 공익을 실제로 실현을 해야 되는 거죠. 그리고 실현을 하면서 그러니까 실현을 해야 되기 때문에 이제 실현을 해야 된다는 게 이제 방법의 적정성, 우리나라 미래성의 원칙 방법의 적정성 매치되는 거고 그리고 공익을 창출하는데 뭐 100의 공익을 창출하는데 뭐 10 정도의 사익 침해만 하면 되는데 쓸데없이 50을 한다. 그러면 역시 안 되겠지. 그거의 침해의 최소성이 명령이죠. 그렇게 하면 안 된다는 거. 그게 여기 문구에 어떻게 나왔나요? 그 미국에서 어떤 문구를 쓰냐면 뭐 narrowly tailored 그죠? 여러분들 봤을 거예요. 또는 necessary 필수 불가결한 만큼만 공유의 창출 필수 불가결한 만큼만 침해를 해야 된다. 뭐 이런 식의 문구로 표현이 되죠. 그래서 strict scrutiny 그러니까 지금 여러분들이 옛날 관계를 보니까 그 문구가 정확히 안 나와서 그런데 지금 나오는 미국 헌법 문구 헌법 표현들을 보면 아주 그 스탠다드하게 나와요. 뭐냐면 restriction on fundamental right, 그죠? Restriction on fundamental right must be narrowly tailored for achievement of compelling government interest. 그리고 이제 실제로 narrowly tailored 됐고 compelling한 government interest들은 이제 쭉 밑에 분석을 하죠. narrowly tailored라고 안 하기도 하고 necessary, has to be minimum necessary. The restriction of fundamental right has to be minimum necessary for 물론 freedom of speech에 있어서는 strict scrutiny 뭔지 얘기 안 해. 얘기 안 하고 그냥 문구를 그냥 써. necessary for narrowly tailored for achievement of compelling government interest. 이렇게 써요. 설명됐어요?
네, 감사합니다.
소리가 안 들어가면 아무 의미가 없죠.
네, 소리 그래서 아예 그냥 빼고 전체 촬영해서 조그맣게.
잘하셨어요. 앞으로 그런 일이 있으면 지체 없이 저를
네, 죄송합니다.
지체 없이 중단하고 키라고 하세요.
네.
Okay. Now we are not talking about this, right? This is substantive restriction. This is how tough restriction. Procedural. Meaning how the restriction should come in. And here the due process clause and search and seizure clause are asking something to be done before any restriction on right takes place. And now we're going to talk about, so we talked about what should take place before the government restricts somebody's property right. Now we're going to talk about what the government should do before restricting somebody's privacy or bodily freedom. You'll naturally think that liberty is more important, more essential than property. So at minimum, something equivalent to what's required for property restriction will be required also for privacy or bodily freedom restriction, right? And you will see whether your guess is correct. And let's look at cats. So what happened in cats? So petitioner was the bottom of page 254. Petitioner was convicted of transmitting wagering information. wagering information이 뭐예요? 도박. wager, 도박이죠. By telephone from Los Angeles to Miami and Boston in violation of federal statute. So he was already convicted. How was he convicted? Page 255 at the top. At trial, the government was permitted, over the petitioner's objection, to introduce evidence of the petitioner's end of telephone conversation, overheard by FBI agents who had attached an electronic listening and recording device to the outside of the public telephone booth from which he had placed his calls. So he was in a telephone booth, and FBI attached some device outside the booth. So they overheard what he was saying, what he was speaking into the phone, and decided that he was in some sort of gambling business and arrested him accordingly. So the petitioner is basically claiming the defense of a fruit of poisonous tree. Fruit of poisonous tree. 독수독과 이론이라고 하죠. Saying, hey, my conviction was based on this testimony of FBI agent, which is in turn also based upon the eavesdropping by FBI agent, which was done without a warrant. Right? Fourth Amendment says search and seizure should not be done without warrant, and there is no warrant here. And the court is about to decide whether this is search and therefore requires warrant. If this is a search, then warrant was required. Since warrant was not obtained by FBI agent's testimony in court is unlawful testimony, which means the conviction has to be reversed. What does the court say? Whether this was a search. Now, before we go forward, what is a search? Right? What is search? Let's say you write on your Facebook. You write on your Facebook that you just committed robbery last week. And the police sees that posting and arrest you. The police seeing the posting, confessing the crime, is that a search? Is that a search? Therefore, it has to be justified by a warrant. What do you think? The police looking at the posting that you made on Facebook, confessing to the crime. What do you think?
I don't think it's a search because you post it on Facebook, you expect others to see.
Exactly. There is no affirmative governmental action changing the default status. The government is not taking really anything away. It's not restricting your right. When do you think the government, think of it this way. If you want to make a donation to the government and the government accepts it, do you think that due process is required? Do you think that some sort of hearing has to be required? No, right? Only when there is a governmental action restricting property right, then this due process right is invoked. Same thing. This warrant requirement kicks in only when the government does something affirmative to restrict your right. But which right? What basic right? Well, privacy, right? The government can do a lot of things, but if they infringe on people's rights, then they have to follow some procedure. That is the mandate, that is the requirement of the 14th Amendment and 4th Amendment. And when that basic right is privacy, then you have to satisfy 4th Amendment. How about when the government restricts your bodily freedom? The government arrests you. What do you think should happen before? Is that restriction of a right? What do you think? Of course, restriction of your physical freedom. For that, you need to have also warrant based on probable cause. So, here it is. So the question is whether listening to something, using or listening in on a conversation of someone in a telephone booth constitutes privacy restriction, and therefore requires needed a warrant before it is executed. That's the question. What do you think? The government's argument is there are a couple of arguments. Let's look at page 255. Second to the last paragraph. The government stresses the fact that telephone booth from which the petitioner made his calls were constructed partly of glass so that he was visible as he entered it, as it would have been if he had remained outside. So I told you about a Facebook posting for everyone to see, right? You all agree that it's not privacy restriction triggering the warrant requirement because, when you do that, when you make a posting like that, you are expecting everyone, including the government, to see it. Or then, if you are talking in a telephone booth in a public place, right? It was on public street. It was all visible. It was made of glass. It's like talking on street. So let's say a police officer was walking by and overhear a conversation on street or at a restaurant, conspiring a crime, planning a crime. Is that privacy restriction triggering warrant requirement? Probably not. So the government is saying, hey, it's the same thing. This is a public area. Yes, there's a telephone booth, but we are in a public area. If you are talking in a public area, then you are risking being heard by other people who may turn out to become government agents or police officers. So this is not really privacy restriction. That is the government's argument. What does the court say to that? It says no. Do you agree with the court? Of course, obvious. The fact that you are visible doesn't mean you are audible, right? The fact that you can be seen doesn't mean that you can be overheard. The government says the person came in and shut the door behind, right? So he was expecting to be private. So there is no like public, yes, the phone booth may be in a public park populated by 100,000 people, and yet you can find private space in there. What's the government's second argument? All the way at the bottom. The government contends that the activities of its agent in this case should not be tested by a Fourth Amendment requirement, for the surveillance technique they employed involved no physical penetration of a telephone booth. This is a more serious argument. Let's say I'm speaking and someone wants to overhear my lecture. Now, instead of attaching a device inside or attaching a device outside, people can wait outside the room. I mean, I can shut the door, but people can kind of place their ear on the door and try to listen in. Is that privacy restriction triggering warrant requirement? Another way of saying is, do you think that it is something that someone must receive consent from me for? Yes, if someone attaches a device inside or outside, then I may be able to say, hey, you cannot do that without my consent. But how about somebody just outside the door, just listening in? Does that require my consent? I don't think so, right? I mean, when you are speaking, you expect the voice to travel as far as it can. And if someone outside the classroom happens to overhear me, that's his luck. I cannot control that. So here the government is saying, hey, here is the phone booth. Somebody is speaking. If there was a police officer just listening in, right, that would not be considered a privacy restriction requiring warrant requirement. Here, yes, we did a little bit more than that. We attached the device, but not inside, outside. So there is no privacy restriction. What does the court say about that?
It's actually
Technical trespass. Does the court say this is technical trespass? Or it's not technically trespass and yet requires a warrant based on and yet triggers warrant requirement? If you look at page 256, the top paragraph, we have expressly held that the Fourth Amendment governs not only the seizure of tangible items, but extends as well to the recording of oral statements overheard without any technical trespass under local property law. Okay? Once this much is acknowledged, and once it is recognized that the Fourth Amendment protects people, not simply areas, against unreasonable search and seizure, it becomes clear that the reach of the amendment cannot turn upon the presence or absence of physical intrusion into any given enclosure. 그러니까 전에는 영장을 언제 받아왔냐면 집 수색할 때. 그럼 실제로 경찰이 들어오죠, 방에. 이거는 사후적으로 수색하는 게 아니라 사전적으로 하는 거죠, 지금. 그러니까 지금 범죄의 증거가 어디에 있어서 그거를 가져오겠다. 이게 이제 수색인데. 그러니까 찾아보겠다는 게 수색인데. 지금 있는지 모르죠. 여기서 범죄 증거는 목소리인데, 피의자의 음성인데, 지금 아직 말을 안 한 상태잖아요. 말을 하면 그때부터 이제 녹음을 하겠다는 거죠. 녹음을 하거나 이제 청취를 하겠다는 거죠. 그런 면에서 뭐랄까, 실시간 수색이죠. 실시간 수색. 사후적인 수색이 아니라. 그러면 그래서 그 전에는 문을 들어갔냐 안 들어갔냐 가지고 들어가면 그러면은 영장 필요하고 들어가지 않으면 영장 불필요하다. 이런 거였는데 이 캣스에서 뭐라고 하냐면 아니다. 실제 안 들어가도 영장이 필요할 수 있다. So the second paragraph, the government's activities in electronically listening to and recording the petitioner's words violated the privacy upon which he justifiably relied while using the telephone booth and thus constituted a search and seizure within the meaning of the Fourth Amendment. The fact that electronic device employed to achieve that end did not happen to penetrate the wall of the booth can have no constitutional significance. Okay. 문장이 되게 복잡한데, the fact that the electronic device employed to achieve that end did not happen to penetrate the wall of the booth can have no constitutional significance. So, that is the cat's case. Now, if you look at page 257, the second paragraph, Justice Harlan says something that is more remembered by people than the majority opinion. He says something in his concurring opinion. He says, so he explains his understanding of the majority rule. He says, my understanding of the rule is that there is twofold requirement. First, that a person have exhibited an actual subjective expectation of privacy. Second, that the expectation to be one that society is prepared to recognize as reasonable. Thus, when a man's home is for most purpose a place where he expects privacy but objects, activities and statements that he exposed to the plain view of outsiders are not protected because no intention to keep them to himself has been exhibited. So it has to meet both requirements. There has to be actual expectation of privacy. Okay. Actual expectation. If you cannot leave something to plain view and say, oh, I expect it to be private. The second requirement, on the other hand, conversations in the open would not be protected against being overheard. So, the second requirement is that You can talk all you want, saying, oh, I expected this to be private, but that expectation is unreasonable. So it will not be honored. So later, Justice Harlan's paragraph is much more remembered as a test called reasonable expectation of privacy. So basically the rule is that whenever the government invades reasonable expectation of privacy, it is considered a search, and therefore it requires warrant based on probable cause. Now, how about seizure? Well, there are seizure of things and seizure of people. Seizure of things is usually evidence. There is not much dispute there, so we're not going to read the case on it. But such of things and such of people, 그러니까 한국에서는 체포구속에 해당하는 거죠. There is not much dispute there, so we're not going to read the case on it. But we are reading case on search because there is a dispute on it. When does a search take place? Because search can take place also remotely as well. I mean, here the device was attached right at the phone booth, but these days the device could have been deployed like 1,000 miles away and still deliver and still complete the search, complete the purpose of the search. So, what does Justice Black say? I mean, this is the same justice who wrote a minority opinion in Goldberg versus Kelly. What is Justice Black's argument there? The paragraph, let's look at Justice Black's paragraph. Eavesdropping was an ancient practice at which common law was condemned as a nuisance. In those days, the eavesdropper listened by naked ear under the eaves of houses or their windows or beyond their walls, seeking out private discourse. eave가 뭐예요? 처마죠, 처마. 그래서 eavesdropping이란 말이 온 게, 그러니까 처마 밑에 가서 집안 얘기를 이제 엿들었다. 그런데 이거는 그 워런 리ኳ이어먼트에 적용 안 되는 것으로 이미 다 이해하고 있었다. 그러면 지금 이 캐츠 케이스에서 있었던 것도 결국에 이걸 조그만 집이라고 한다면 집 처마 밑에서 사람이 이렇게 듣는 거나 거기다가 뭐 이 녹음기 같은 걸 붙여놓고 듣는 거나 뭐가 다르냐. 제가 지금 강의를 하고 있으면은 누군가 밖에서 이렇게 살살 들으면은 집중을 해서 들으면은 내 목소리를 들을 수도 있다는 위험을 감수하고 하는 것처럼 그냥 공공장소에서 그 폰 부스에서 얘기를 하고 있으면 누군가 밖에서 서가지고 내 목소리를 들을 수도 있겠다라는 위험을 감수하는 건데 왜 그거를 기계로 했다고 해가지고 갑자기 불법적인 수사라고 해서 워런트를 필요로 하도록 워런트가 필요하다고 얘기하느냐, 영장이 필요하다고 얘기하느냐, 이런 주장이죠. Think about this. Let's say you are a drug smuggler and you are conducting a deal and you want to do it secretly away from the police. So what you do is you do it on a boat out in the ocean, far from anywhere else. So FBI, the police, want to take evidence of that deal. So the police boat approaches like within 20 miles. So the drug smuggler thinks that they are alone. There is nobody to see. But the police have this ultra strength micro telescope or has a satellite that can view, right? They can take a picture from afar above. What do you think? Is that search? Does the police have to get a warrant before taking that telescopic view of the crime scene? If that's not search, why is this search? Right? Yes, in this boat situation, it's the distance. It's a distance that's hampering listening in. Well, yes, it's the distance that's hampering investigation. Here, what's hampering is not distance, but the word. But in both cases, you use tools, physical tools, to overcome that hindrance, right? So, when you know that people can easily, when you know that people and the police have access to these physical tools to overcome distance or physical war, then can you really say your expectation of privacy is reasonable? So, although it was a minority argument, it is not an easy argument to dispense with. Really, what's the difference between listening in with your own ear and amplifying your hearing capacity with a device? Or what if the police officer wears a hearing aid 보청기. And this hearing aid is not to compensate for people with a low hearing capacity, but let's say it is a hearing aid that amplifies ordinary people's hearing capacity beyond the ordinary level. And you've seen people like that on movies. You'll see them on Avengers. You'll see them on superhero movies. Bionic woman. Bionic is the term that you use to describe the technology of amplifying people's physical ability using mechanistic tools. So if the police officer had a hearing aid in his ear, does it suddenly become search and therefore you have to get a warrant? It's not an easy question, but here the court said the expectation of privacy inside the phone booth, expectation of privacy inside the phone booth is reasonable. Okay, so now let's look at California versus Greenwood, page 258. You don't have a complete case, but it doesn't matter. You can get a sense of it. Police on California versus Greenwood, like number 2 garbage, right? Police on 2 occasions had a neighborhood garbage collector pick up opaque plastic bags of garbage which Greenwood had left at his curb for pickup and turn them over without mixing their contents with other garbage collected. On each occasion, evidence of narcotics use was found, and each discovery serves as the basis for a search warrant to search Greenwood's home, which upon execution led to the discovery of narcotics. The question is whether collecting the garbage will constitute a search. What do you think? Do people have expectation of privacy, and is that expectation reasonable on the garbage, on the garbage bag that they leave outside the house? The court says, we conclude that the respondents exposed their garbage to the public sufficiently to defeat their claim to the Fourth Amendment protection. Then how about garbage cans in your own home? Do you have a reasonable expectation of privacy? With respect to the things inside your garbage can? I think so. Right? But as to the garbage bag, if the police, even stray cat, dog, can bite into the garbage bag. If the dogs and cats can do it, why cannot the police? You cannot have reasonable expectation of privacy with a garbage bag you leave outside. Now, having said that, So we are talking about what due process has to be respected. So we are talking about what due process, we are talking about when due process should be applicable. Due process requirement has to be satisfied in search and seizure. Let's come back to the question of what that due process is. And we know that generally there has to be advance notice, hearing, and neutral decision maker. But on search and seizure, what should happen? So let's say warrant was required for cats, and the Supreme Court decided that warrant was required. And the government tries to say, if you look at 256, toward the bottom, the government is arguing let's see. The third paragraph. The question remaining for decision is whether the search and seizure conduct in this case complied with the constitutional standard. In that regard, the government's position is that its agents acted in an entirely defensible manner. They did not begin their electronic surveillance until investigation of the petitioner's activities had established a strong probability that he was using the telephone in question to transmit gambling information to persons in other states in violation of federal law. Moreover, the surveillance was limited both in scope and in duration for the specific purpose of establishing the contents. And the agents confined their surveillance to the brief periods during which he used the telephone booth, and they took great care to overhear only the conversations of the petitioner himself. Okay? So what the government is saying is, hey, warrant is just a procedural requirement. But substantively, we took care of it. We acted in a very careful manner. And the court says, the bottom, accepting this account of the government's actions as accurate, it is clear that this surveillance was so narrowly circumscribed that a duly authorized magistrate, properly notified of the need for such investigation, specifically informed of the basis on which it was to proceed, and clearly apprised of the precise intrusion it would entail, could constitutionally have authorized. 이런 식으로 하는 거라면, 이런 식으로 할 이런 식으로 수색을 하겠다는 계획을 냈었다면 영장이 나왔을 거다. 그러니까 이럴 때는 영장 안 받았어도 어차피 받을 수 있는 내용의 수색이었으니까 그냥 봐달라고 하는 거죠. The court is saying no. Procedural requirement is procedural requirement. It has to be done. So, that is the content of the procedural requirement. There has to be so this is general. This is privacy restriction. On privacy restriction in criminal investigation. Requirement is that there has to be advance approval, right? By who? The court doesn't talk about it, but the term warrant encapsulates, the term warrant includes the requirement that it is issued by who? Judge. Okay. And then it has to be based upon what? Probable cause. How about advance notice? I mean, for violation of property right, there has to be advance notice. Notice to who? Notice to the person whose property is being taken, right? How about privacy? Can there be requirement for advance notice to the person being investigated? Or if advance notice is given, evidence can be destroyed. And the person finding out that he's under investigation may run away. So that is not required. But there is okay, or let's just leave it there. That there has to be advance approval by a judge based upon probable cause. That is the due process that has to be satisfied for privacy restriction in a criminal investigation. If you look at page 258, the fifth line from the bottom, there is a case Smith versus Maryland, 442 U.S. 735, 1979. This is a case about phone records. So the police obtained phone records of a suspect from the telephone company. And the question is whether you have reasonable expectation of privacy on your telephone records. Not the contents of your telephone conversation, but the records of when and how long and on which number you had the phone conversation. What do you think? Do you think that that's a privacy restriction, and therefore, for the police to get it, they have to get advance approval from a judge? And now you know why warrant has to be issued by a judge, right? I mean, you learned that from Goldberg versus Kelly. Says it has to be neutral. Who are public employees that are neutral to the government, which is their employer? Who are the government officers considered to be independent of their employer? Well, judges. That's why warrants have to be issued by judges. Okay. Now that you know, now having said that, going back to this question, do you think that you have reasonable expectation of privacy on the phone records you have, on the phone records? On one hand, hey, you are letting the telephone company know. I mean, telephone company has the information. Why not the police? You don't have a privacy interest there. On the other hand, the fact that you shared with one person doesn't mean you lose privacy. I mean, let's say you are in a hotel room. Do you have a reasonable expectancy of privacy in your hotel room? Yeah. Yeah, but cleaning ladies come every day to clean your room. Do you lose privacy? Do you lose privacy interest? Do you lose expectation of privacy just because cleaning ladies come in once a day? No. So the fact that you share the information with other people doesn't destroy your privacy interest as long as that other person is somehow bound by contract or somehow has obligation to keep the information safe, right? But the surprise was that the Supreme Court decided that phone records are not protected by the Constitution. On the argument that, you know, by sharing with a phone company, you lose privacy interest. It is a badly criticized decision. Even Congress hated the decision so much that they passed a law requiring advance approval of judges before getting phone records. Because the fact that the Constitution does not provide, does not require due process doesn't mean the Congress can choose to provide due process. All right? I mean, the Congress can actually do more than Constitution requires. Okay, it's 1:10. I think I'm out of time. So next week we'll talk about, not next week, May 25th, I think. Yeah, we'll talk about Spinelli, Miranda, these other cases. Okay, thank you.